Defense.
Thank you, Judge.
Yes, thank you.
Good morning, ladies and gentlemen. I want to thank you so much for spending the month of July with us, practically. I'm sure that's not what you thought you would be doing this summer. It's been a long 3 weeks, and I always tell my jurors, other than military service, jurors' duty is one of the highest civic duties you can do. And from court personnel, deputies, the prosecution, especially the defense, and the clerk's office, we all want to thank you for doing your job. It's been a long trial. I know it's not a happy thing to do, but hopefully you've enjoyed it and this experience. And you have the most important role in this courthouse right now. You have to decide the guilt or innocence of Mr. Amato. So I want to thank you for that. All of you were chosen over 3 weeks ago because we all thought that you would be the perfect people for rendering a fair and impartial verdict. And that's all we're asking. That's all we're asking. I have my job to do. Obviously, the prosecution has their job to do. And hopefully, we did a good job, both of us. Now, as Mr. Leo, the prosecutor, said, that the state has the burden, and we know that. They have the burden to prove this case, every element of this case, beyond and to the exclusion of a reasonable doubt. Judge Rexsealer, she's going to read you the definition of reasonable doubt. You'll be able to take the jury instructions back to you, so I'm not going to go over them. Dominic Leo has touched on some of the elements, that we have to show. There's different elements, but you'll get that opportunity. So what I want to do is go over the state's witness, but I want to talk first a little bit, just briefly, about the state's closing in the beginning, about the possible defenses. Now, the defense, throughout this whole time period, ladies and gentlemen, I did not put forward, none of us put forward a defense that a random intruder did this to the Amato family. We didn't put that forward. We didn't put forward that it was a drug deal gone bad. We didn't put forward that this was a murder-suicide, nor did we put together, I never, ever, and no one on the defense team ever accused Jason Amato of this. As you recall, my first thing that I told Jason, I'm sorry. I'm sorry for your loss. So please don't, think that we are trying to put these nefarious defenses forward. We're not. What we're doing is defending Grant Amato for 3 counts of first-degree premeditated murder. And that's my job, and that's what I'm standing up here doing. Please, just remember that. Now, I'm going to go through the witnesses. I don't think I'll be as long as Mr. Leo. He's touched upon a lot of items, but I just need to touch upon some of the state's witness. Now, the first witness was Chris Sisko. He's the one who called the infant and well-being check. Now, he was a straightforward witness, but there was a couple of things you got from him. You got from him that Cody, you saw a picture of Cody, that he always wore long sleeves because he was always cold. It's kind of important because these gloves are going to be in there later on. And, that's kind of important. And he's known Cody for a long time, and he always said he was always cold, and that's why he wore long sleeves. The next witness was Todd Moterson. And once again, he also confirmed that it was a little chilly out there that day. And the reason I'm bringing this out because I want to talk to you about the gloves later on and the reason that Grant had them. You noticed that Todd had a body cam, and he testified he was wearing a jacket because it was chilly out that day on January 25th. One of the things he did also say is that when he was going through the house with his body cam was that the blood was still wet. And I'm saying that because, the state committed to this timeline They committed to a timeline that, everybody died at a certain period, and, and they're holding to it. And I'm here to submit to you that timeline is terribly wrong, and we'll go forward why. Now, the next witness was, Arthur Rubart. And Arthur, he's a crime scene investigator, and he testified about all the things that he did. But what you heard from the state is that right away, the state attorney had this case solved. And they put forward this, there was no reason for Arthur to do all these things. Ladies and gentlemen, I will submit to you, yes, there was. There was a reason to process this home. That's his job. He's a crime scenes investigator. His job is not to solve the crime. His job is to gather evidence, to gather blood, to do DNA swabs, to look for footprints, things of that nature, things of evidentiary value. Did he do that? Unfortunately, he didn't, ladies and gentlemen. He did not do that. And he didn't know. Now, the thing important here is that when was there a suspect? According to Mr. Rubart, this investigation, his job lasted 5 days in processing it, and he couldn't tell me when Mr. Grant Amato was a suspect. He couldn't tell me that time frame. However, the next witness said that Grant was a suspect right away, and that was his supervisor, Ms. Snyder. Now, the first time that she testified as to the trajectories, and she was just testifying about the trajectories, and, that doesn't say who the killer was, okay? That just doesn't do it. I asked her, why wasn't all these things processed? And she didn't give me a reasonable explanation why all these items were processed. Why wasn't the garage door processed? Why wasn't the wine glass, the laptops, especially the phones? Why weren't the phones processed? And you have to remember something. Back then, and during that time, did they know that this finger was so important? Did they actually know that the finger on Chad Amato was critical? Absolutely not. They came up with, I don't want to say they manufactured evidence, but they came up with this theory that here's a clean finger, and that was used to activate his phone. She said that she did scrapings, and we'll get to that later on. But on January 25th, they did not have any physical evidence to speak of because they didn't process everything properly. And I can't help that. Even though that's their job, they didn't do it. Now, we go to the other witnesses that testified, and one of them was Daniel Anderson, the lead investigator in the case. And Daniel Anderson, ladies and gentlemen, was very important because he's the one that did the initial interview of Grant. And what did he do? He put a bolo out on him and they found him at a hotel. They found him at the Doubletree Hotel, and they took him, not into custody, but they interviewed him. They interviewed him for 7 hours. 7 hours. Now, the first hour we know was just to observe him, just to see if he's going to talk to himself, make incriminating statements, things like that. And they're watching him. We know that. That's a police strategy. And I'm not faulting the police strategy, but that's the way they do it, First, the first hour, they observe him, then they're trying to gain trust with him. They go in there and they talk about him. And you got to remember, back at the time, they didn't know what Grant did. They didn't know that, as the prosecution says, he's expert. He's a medical expert. He knows about blood. He knows about DNA. They didn't know that. Arthur Rubart, the crime scene investigator, certainly didn't know that. I mean, at his point, he's just a, quote, person of interest. So they interviewed him for 7 hours. And what did they get out of it? They got mostly the truth. They came up with 2 lies that he corrected. One was the time that he met Cody, and 2, the time that he left. He said he left earlier, then he said he left around 12:30. They used different strategies. They used strategies like, we have the surveillance. We have we have the cell phone towers. We know where you're at. They didn't know at the time that Grant didn't even have a telephone because his dad had shut it off. They talked to him and tried to make him feel comfortable. They trying to establish a friendly relationship. That's what he said. You know, and they talked to him about his job and how he lost his job, and they talked about his dad, and they kept trying to make him feel bad. They kept trying to say, you know, things like, get it off your chest, you know, you'll feel better now, we can help you. They can't help him. We know that, but it's just a strategy. It's just a strategy. They, you know, one of the key things they did, ladies and gentlemen, it was when the phone rang. Anderson looks at his phone and says, oh, that's not good. Trying to entice him to do a confession. 7 hours, and what did they come up with? Nothing. They did not even rise to the level of probable cause. And that's just merely a suspicion that this person more than likely committed a crime. They did not even come up with probable cause in this case. What did they do? They let him go. They let him go. Even though Anderson said at one point, I have 95%, I know what happened. But they let him go, ladies and gentlemen. And I asked Anderson, what additional evidence did you have the next day? And you saw him in the witness stand, he sort of looked puzzled. They didn't have anything, they didn't have any more physical information. They didn't have anything else. They had no more information, yet they submitted what they had to a judge who signed an arrest warrant. And bam, he was arrested like that. That lasted, and you saw the video, he was cooperative. Did he ever leave? Did Grant ever leave? He could have left. He could have left the day before. If he committed the murders, why didn't he leave right then? As Mr. Leo just said, he had a passport with him. He's speculating that he's going to go to Bulgaria. Why didn't he go right then? He wasn't even a suspect. No, at the time, if you take the time that he left, nobody knew. Nobody knew what happened. Nobody knew what happened until 9 o'clock the next morning. He could have been halfway to Bulgaria there. Did he go? No. He didn't go anywhere. Did he go? Even after he was interviewed by Seminole County Detective or Investigator Anderson, did he go? He didn't go anywhere. He went to the Lake Mary Hotel. That's where they put him up at. Was he under arrest? No. Was he really going anywhere? If he wanted to, absolutely not. You know, the police would have followed him anywhere. But yet, you know, they let him go because they did not have probable cause. And suddenly, without any additional information, they found that this guy more than likely committed a crime. Grant's, all his stories added up. The toll records added up. You heard from the Wi-Fi, the public's Wi-Fi. He said he went to the public's Wi-Fi. They checked it out. Troy Roberts testified. Yes, he confirmed that Grant was telling the truth, that his laptop was hooked up to the public's Wi-Fi. You knew that. You heard from Jason Amato. Jason was an important witness in this case. He testified, and you know, I said, I'm sorry. I never, ever accused Jason of committing this. Never, ever. And please, that's totally wrong. I never implied that. I said I was sorry. He described his family relationship. He described his family relationship as a typical family. They all played when they were kids. And one of the things that was brought up that, you know, is Chad is right-handed. He was asked that in direct testimony, is Chad right-handed? Well, his dad was right-handed, and there's no reason to believe that Grant didn't know he was right-handed. He played baseball catch with his dad, too. So he was right-handed. You know, what's the big deal? Is they're starting to worry now about this fingerprint scan, or you know, things like that, or the holster. And then the holster. Why, ladies and gentlemen, didn't they process the holster right away? They didn't. They didn't do it till later. Why didn't they process the gun right away? We don't know. You know, we just don't know. He said that he last talked to his mom. Jason last talked to his mom on the 16th of January. It was a good conversation. Grant was getting better. Grant was discharged from the hospital or the rehabilitation center, however you want to say it. And why was he discharged? Because the doctor said there was nothing more that he could do for him. He was fine. It wasn't like he walked away. That wasn't the testimony Jason said. Jason said the doctor said he was okay. Okay, so that's not the point. The family, they come back, the family's pulling together. I know the dad's upset, yeah, who wouldn't be? You know, he lost a lot of money, but they were a family. They were a family, and believe, and use your common sense. And one of the common things that we always say, don't check your common sense at the door. okay? A lot of families have crisis, whether it be drugs, whether, it could be a lot of things. This is kind of an unusual thing, granted. This is something, to do with this Bulgarian lady. But nevertheless, Grant was part of the family. The family was pulling together. Jason testified to that. Jason testified that everybody was coming back together. Now, his significant other, not wife, but basically his wife, Christy Vernell, once again, I'm sorry for her loss, but she was forthright. There was a time during her testimony, though, that she did say that Jason received a phone call from Chad. She kind of mumbled a little bit, no, it wasn't that night. But the gist of it is that the phone call was normal. The family was coming together here, okay? Now, Arthur Rubart, the crime scene investigator, testified again for the second time, and this time was the hotel. And the hotel, the first hotel that Grant went to, that's an important crime scene. That is a very important crime scene because that is where Grant went from his car to the hotel, and that's what he testified to, and we know that's the truth. We know that's the truth. Nothing was found, no blood, no blood, no DNA of anyone else, nothing incriminating was found. And that goes back to the scene. That was a bloody mess. It is what it is, and I don't want to show you pictures of it. How in the world was Grant Amato able to do all these things without getting a scintilla of blood on himself? And we'll talk about that in a little bit. Eric Brothers, he testified. He was another analyst, crime scene investigator for the sheriff's office. He did a wonderful job. Now, he processed the car, Grant Amato's car. And that car, Grant left from the home to the car. If he had any traces of blood, anything of evidentiary value on his body, on all the clothes that he gathered, it would have been found in that car. He took the light source that he talked about, he talked like, it would say like when a 10,000th particle of blood it would indicate. Not even on the floorboard where the floor mats were at, where Grant had to have stepped on, was there one scintilla of blood. How do you account for that? He's not magic. Not one scintilla of blood was in that car, and he did a thorough exam of that automobile, and I commended him for it that he did. But nothing was found, no DNA or anything. Now, Janelle Kennedy testified from CVS, and that was perfectly normal. It was a normal video. It was a normal day. There wasn't very much, of evidentiary value there. The other witness was Paul Schatz from the toll records. He confirmed that Grant was telling the truth. He confirmed that Grant went to that interview, the toll records, that the time, exactly the way he said it, exactly the way he told Anderson. It all matched up. Grant wasn't deceiving anything to Anderson. Now, Anderson had to come back and testify about the letter, and that was based on one of the jurors' question, who wrote that letter, that little card that the prosecution talked about. And Grant admitted that he wrote it. He just said he was memorializing it. He didn't lie. Now, there was a witness that I really want to pay attention to, and that's crime scene, or not a crime scene investigator, but Geraldine Blay. Was she forthright? I submit to you she wasn't. She's the one that's going to lay out the digital footprint. She's going to lay out the digital footprint of everything that happened. She can't tell you anything about the bloody mess and how there's no blood on Grant. She can't explain, because it's not her job, about there's not a piece of blood or anything of evidentiary value upstairs. Her job is to examine the laptops, the cell phones, things like that. Now, we know, very first thing, no DNA swabs, no checking for blood on any of the laptops, any of the phones, and especially Chad's phone. There was nothing there. And there was a little bit of testimony, well, the phone was clean. We know that Chad was a meticulous person. In fact, if you recall, I took out a piece of paper to Jason, and I said, would your dad do like this? That was a set of rules. And I said something like this, and he says, no. I said, what? This is odd. No, my dad would have this perfectly inside. He would have it perfectly inside. She did a composite, and I'm going to show you the composite. She conveniently left out about the fingerprint access. She didn't put that in there. She put that he accessed the phone, but he did not about the fingerprint access. And that's huge in this case, because that blows up the state's timeline. The state wants you to believe that Grant was able to go through that bloody thing and see it's not up there. It just says, the USA Bank application. She doesn't put in there that it was accessed via fingerprint biometric access. She doesn't put that in there. Because somehow the state wants you to believe that he was able, Grant, was to go into that bloody mess, not leave anything, and take the dad's finger and press it on his phone. Now let's use our common sense. We all have phones. We all have cell phones. Is your index finger the one you would use for your passcode? I would submit that's not. You use your thumb. We all know that. Use your thumb. But the investigators said, well, hold on, there's a finger that's clean. That's got to be it. Investigator Blay, what she could have done very easily, because this is her job, this is her specialty, was go to the settings of the iPhone and look at the fingerprint. That's her job. She's a supposed expert at this. They could have got that phone and they could have obtained that fingerprint. It was easily done. And all they had to do was match it up to what? Chad's fingerprint. It was a simple process, and if she's a thorough expert, that's what she could have done, but she didn't do that. You've heard no evidence at all that Chad's, you don't even know that what finger, thumb, or what hand he used to access that phone. But we all know from our common sense, you don't use his right finger. Plus, and think of this now, he's right-handed, right? So he takes, all right, I'm going to use my phone, and I'm left-handed, but I guess, I don't know if I hold it right, but I hold my phone in my right hand. Are you going to use your right finger to access the phone like this? Does that make sense? Are you going to use what commonly most people would do, hold the finger in your right hand and use your left thumb? We don't know. And the reason we don't know is because Blay didn't do her job. It could have been easily checked out. And the other thing about these phones, isn't it remarkable how Mr. Rubar could walk in and all of a sudden the screen appears? And when he walks into the hotel room, all of a sudden, magically, the phone, the screen on the laptop appears. He said he didn't touch it. Leave it up, I'll leave it up to your deliberations to think about that. Now, the other thing about her, Blade, she testified that Cody's phone was plugged into the laptop. So, okay, we know that. How do we know Cody didn't do it? She said that it was put in the recovery mode, and she said that is for wipe or restored. And she mumbled something about, like, if you want to get your iTunes back. We know that Grant didn't have a phone because it was shut off by Dad. It wasn't found with the phone. Was he restoring his iTunes? Did she show you, other than just her testifying, she just testifying that it's only used either to wipe or restore when it's put in the recovery mode. Did she back that up with any documentation at all? We just had to rely on what she says. That's all you have. And she didn't do a thorough job because it goes back to the settings. She could have did so much more to gather more evidence to overwhelmingly tell you what was going on with that phone, and it wasn't done, ladies and gentlemen. It wasn't done. What about the metadata? She wanted to say that, imply that those pictures of those cards were taken that night on the 24th. She tried to imply that until we pointed out, well, Margaret's card is expired. It expired at 12 of 18. So what does she do? They go back and they look at the origination dates. Those pictures were taken back in September. She was trying to mislead you, ladies and gentlemen. That's what it was. And call it what it is. She was trying to imply that those pictures were taken that night, and we know they weren't done. And what was her backdrop? What did she try to straighten out? Well, maybe he manipulated the dates because she wouldn't admit that he was tech savvy. But maybe he admitted he manipulated the dates to look like it was actually back in September and it was really taken that night. That's not true. Why would someone have an expired card? Why would you take a picture of it? Why would that be, possessed by him? It wouldn't be. Don't fall for that. Don't fall for that. Her testimony is based on the assumption that Chad, Cody, and Margaret are all dead. She's manufacturing evidence. And what about the Blink app? She talks about the Blink app. She knows, and she readily admitted she doesn't know anything about the Blink app. It would have been easy to find out. Just look at the manufacturer, look at the warranty, not the warranty, but the registration and all that, the information about how the Blink app works. The Blink app does not store data. Does she know that? No, she doesn't know that. They're trying to imply that they're trying to erase all the videos in there. It doesn't store. Have you heard any evidence that it does? No, they didn't bring in the manufacturer or somebody from that company to explain how that works. And then what about the Echo? We know the Echo stores. You didn't hear any evidence about the Echo, did you? The Echo could have told you everything. Everybody complains about these devices, the invasion of privacy. You didn't hear any evidence about the Echo and what happened. Now, Nicholas Stewart testified. Now, he was an important witness too. He was forthright. But what was important about him? They were making a thing that they were trying to wipe the phone in the recovery mode. I would submit that that's not true, but let's assume that it is. We know from Chad's phone that he was Googling similar actions on 119. He was Googling about how to bypass passcodes. That's from Chad's phone. On 119, he was Googling similar things. What does that tell us? We know Chad was alive on 119. Nobody's submitting that he was dead. A lot of this forensic footprint, you've not been provided a thorough examination. You've not been provided that. We have to rely on what Blade tells us with nothing to back it up. We just have to take her for granted. It all goes back to the one issue where we know the state is scrambling is about the fingerprint. That's huge. Because I would submit to you at 12:08 a.m., Chad Amato was alive. Now, let's talk about some of the friends. And here, I'm going to go ahead and jump ahead. Let's talk about Sloan Young. How do you get past Sloan Young? How do you get past Sloan? Sloan testified, bless her heart, she had testified in defense. She wasn't called by the state. She was called by the defense. And what did she say? Cody got a phone call at a little bit after 9, and he told her it was from my dad. And she said that he picked up the phone and he was talking on the phone. The state wants you to believe that that's a text. Again, use your common sense. Is that how you text? Holding your phone up like that? No, he was having a phone conversation. He was having a phone conversation with his dad. With his dad. After 9 o'clock. Now, if his dad's alive at 9 o'clock Do you think his mom has been dead for 5 hours? No way. No way. Margaret's still alive too. And just because there's been no activity on her work computer, that does not mean she's dead. That doesn't mean she's dead, okay? They want to say that she's dead, so if you want to believe the state's theory, that means that Chad's been walking around the house for 5 hours and poor Margaret's laying on the desk dead. That didn't happen. That didn't happen. So we know Margaret's alive. The state's timeline does not add up. We know Margaret's alive. We have to, we don't 100% know, but make a strong assumption, use your common sense. We know Chad's alive after 9 o'clock because he was talking to Cody. We know that. Sloan Young told you that. The defense called her. State didn't call her, the defense called her. Now let's talk about Jericho Fine. Let me ask you, he's a friend. He's a family friend. He's known him for a long time. Was it really necessary to show Jericho Fine the autopsy photo of Margaret Amato? Did he really have to do that? No. It was for shock value to you. And shame on them for doing that. That was not necessary. You're just trying to inflame emotions. Don't fall for that gimmick. Blake Turpin. Oh, Blake. Boy, he has an incredible sense of timing, doesn't he? Just incredible. We know from Jericho that Blake is like the centerpiece of the Remedy, the airsoft club. They go there every week, they have dinner, they hang out there, and they all get together. But Blake didn't want you to believe that. Blake said, I'm a very private person. Don't, you know, it's just very private. Hardly anybody goes over there. Finally, he admits, yes, on a weekly basis for years, they'd come over. And he, I will submit, is manufacturing evidence. You know they don't have a gun. He knows they don't have a gun. And all of a sudden, he's become friends with Jason. He was friends with Cody and Grant, very tight since high school. I asked him, but recently, yeah, I've been talking to Jason on a regular basis. Have you been talking about the case? Yes, we have been. Think about that. On a regular, they know they don't have a gun. In fact, they brought some blue gun. I see that, Madam Clerk. This is what they started out with. This is a play gun. It's an imaginary gun that the states used for like Christine Snyder to show how the holster was done with the cross draw. That's all they had. Not for Blake, though. Blake, with his incredible sense of timing, testifies that, I think, Grant stole my gun back in January. That's going to help the state, isn't it? He bought the gun 3 years ago. The last time he saw it, this responsible gun owner, was June of 2018. 12 months later, he reports it's stolen. Why? Because he wants to help the state, and he produces a gun, an imaginary gun, the Jericho gun, the one that Jericho thought was cool because it had his name on it. He reports it in June of 2019. You'll see from our submission that we produced, there was a gun missing. See, this is the problem. He sold all his guns, Grant did, for money back in, I think in September, July, you can check the dates. He sold all his guns, except for one firearm that was missing. The defense found out where he sold that one. You heard that yesterday from Sam Kors. The revolver that was missing, we explained that it was sold. Now, the state doesn't have any place of a gun, and here comes, with incredible timing, Blake Turpin. Well, I tell you, we had dinner this one night in January, and Jericho had to do something substantial, and he went, and Grant had to urinate, so he went in my room. And now he comes back and says, well, Grant took that gun. But yet, when he's in front of law enforcement, Orange County Sheriff's Office, he tells the deputies he doesn't really know if it was taken or not. But he makes the report, conveniently to help the state with their case, ladies and gentlemen. And what about the bucket of ammo versus the special bullets? Because they want to get these special bullets in. Ladies and gentlemen, he's manufacturing evidence. He pulls out and says his plastic bag, which has 100 bullets in it, and 4 bullets are missing. Yet, he has 2 buckets of ammunition just right in his closet. He's just manufacturing evidence to help the state. That's all he's doing. That's all he's doing. And he doesn't even leave it there. He pushes the envelope. He goes farther. He gives the state, just a few days ago, pictures that are 7 years old showing a weapons training class that took 2 hours. Just an incredible sense of timing, ladies and gentlemen. 7 years ago. And they get offered in evidence, and they're admitted into evidence. Like this was something planned or something, that he has a special training. It was 7 years ago, and it was 2 hours, and it was a group thing. It was a road trip. It was part of the gang. That's all it was. But you're being told that, yeah, this is the stuff that he does. He's trained in this. He could shoot all these people. He could shoot upside down. He knows all this self-defense tactics. It's a bunch of garbage. That's all it is. That's all it is. They're just grasping and grasping because their timeline just doesn't add up. They can't get past that fingerprint scanner. We know it. They can't get past it. Richard Root, the FDLE person, what did he say? He could not exclude the Glock 17 found on Chad as the gun that was used to kill Cody, Margaret, and Chad. He couldn't exclude that gun. Remember that. Their own experts said they could not exclude that gun. But Blake will take care of that. You know, there's this special gun that he uses. Now, how about Edgar Perez, the FDLE analyst? Yeah, and this is something you probably don't know, but when I did the cross-examination of Edgar Perez, that was, and we got, the report came in, that was something that we were going to do, but graciously the state put it in evidence, okay? It was sort of out of order. But nevertheless, the following. The scrub bottoms from Grant Amato. The scrub top from Grant Amato. The tissue paper, remember the tissue paper with the brown stain that was found upstairs? Underwear from Grant Amato, white shirt from Grant Amato, shoes from Grant Amato, left and right. DNA testing, thoroughly tested by FDLE. Not a scintilla of blood. Not a scintilla. The black leather belt from Chad Amato. The holster from Chad Amato. Not a scintilla of Grant Amato's DA. No, I don't need shock value. I'm not going to do shock value, but you remember how Grant Amato's body was sprawled out. It was a bloody mess. I can't help that. It was a bloody mess. But somehow, he was able to go all around that, reach over, take the belt off, put the holster on, manipulate the body, and not get a scintilla of anything of evidentiary value. His DNA was not found on the belt. His DNA was not found on the holster. His DNA was not found on the gun. How did he do that? He didn't. The picture speaks for itself. How in the world could he have done all that and not leave anything of evidence? The cell phone clip from Cody Amato's bag, the pair of jeans, nothing. The one swab handle and clips of the gun box from Cody's bedroom, nothing. The piece of paper towel with dark stain, nothing. Nothing at all, ladies and gentlemen. This all adds up to reasonable doubt. That's the whole point of this. This all adds up to reasonable doubt. They had to prove the case. You heard financial records. He's not being charged with money laundering. He's not being charged with theft. He's being charged with first-degree premeditated murder. And this is serious. You dot your I's, you cross your T's. You don't let Blay come in here and testify as all these instruments with nothing to back it up, just her opinion. That's not the way it's done, ladies and gentlemen. Eric Brothers. Very honest, straightforward. He did a thorough job. He, in fact, came back to testify that he misspoke and that he did, in fact, check the door handle for blood. He didn't have to do that, but he did. And what did he find? Nothing. Absolutely nothing. Now, you heard from the neighbor yesterday, Jennifer Sawyer. She heard less than 5 gunshots, less than 1, 8:30 to 9:30. She can't really confirm. We know from the testimony from the other neighbors, like Funk, who testified yesterday, he heard 3 pops in the morning, but he's never heard gunshots in a house. We know the area. It's rural Seminole County. Hearing gunshots, or what you think might be gunshots, is not an uncommon thing over there. It's not an uncommon event over there. We know that for a fact. So give the weight it is. Let's talk about the medical examiner. This comes back to the crux of our case. Dr. Jones. A doctor, a medical examiner, does she have any bias in this case? Does she have any reason to mislead the jury? Absolutely not. And what did she testify to? She can't tell the time of death. We know that. And the identification method of the body was on January 25th, and the method was fingerprint scanning. It was in her report. Her medical investigator's report, who was at the scene, and once he arrives, he's in charge of the body. That's a fact. But what do we have, though? The state attorney, for the umpteenth time, calls Mr. Rubart back to the stand. At any time, he was asked, at any time, did you see fingerprint scanning done of the body? No. Well, let me tell you from testimony, if you recall. He was there from 2 o'clock to 9 o'clock. Was he guarding the body? Was he looking over the body? Maybe, because he wasn't doing anything else. But no, he wasn't. He was taking photographs. He was doing his limited processing of the scene, and that's a fact. The medical examiner comes in, the investigator. He takes control of the body. He puts it in the body bag. He prepares it. He prepares the identification, and he puts it in his report. And what did he put in his report? On 125, the identification of the bodies was done via fingerprint scanning. Now, granted, Dr. Jones was forthright. I don't know the idiosyncrasies of the fingerprint scanning, but it was done. Now, is Rubart suggesting that the medical examiner is lying? Is that the report is untruthful? Don't buy into that, of course. She's not lying. She has no interest in this case. She's just testifying as to the facts. She does 250 autopsies a year. She knows the process. She knows how the body's bagged up. And specifically, when something, and all the investigators have testified, when they see something on the body that's important, and I asked this question, they're bagged. The hands are bagged. They're bagged with paper bags to preserve the evidence. This wasn't done in that case. So these bodies were put into the bag. Nothing was done to preserve the fingers. We know that Snyder did the scrapings of the finger, and so she manipulated it. And remember this too, and use your common sense. When you open your cell phone with your thumb, whatever finger you use, you have to press down. We know that. You have to press down for a while. The autopsy report said that there was a laceration on top of that right index finger. And also, you were showed the photograph. Did you see underneath there? Come on, ladies and gentlemen, don't buy into this. They're misleading you. It's shameful. They're misleading you on this evidence. That Grant did not Grant did not manipulate this body for this fingerprint. It didn't happen. And then Blaze, she was so brilliant, she was able to guess the passcode. Maybe he could be brilliant too. He didn't do that. He didn't do any of that. She didn't even show you. And I go back to the cell phone. She didn't even go to the settings to show you the breakdown of the phone. Why? She's supposed to be this forensic expert in this stuff, and she didn't do it. And then when Christine Snyder was called back, oh boy, they're just going to testify to whatever makes them look good for what they were supposed to do. Part of the judge's instructions, ladies and gentlemen, is to examine the witnesses and how they appear on the witness stand, whether they were honest and straightforward. No, there's no way. They're just trying to manufacture evidence. They're trying to insinuate and impugn the integrity of Dr. Jones, the medical examiner. They didn't say anything about this earlier till I brought it out with Dr. Jones. And you know, they started scrambling. Call Rugard back. They started scrambling. Damn, he's got us. So we know that Chad was alive at that point. You don't have enough information on the Blink application. No other information, just from what she says. And it's not gospel. Don't accept it as that. Allison Leneve testified, the GSR lady. Now this is an important piece of evidence. These gloves, can you get ready for these gloves had GSR on them. Not that much, but they had GSR. We talked about the transfer of GSR. We also talked about the DNA, and I'll get into that in a second. These right here, ladies and gentlemen, are gun inserts. And this is Cody's closet? This is Grant's closet. What do you have there? You have gloves laying on gun inserts. Those gun inserts have GSR on them because the guns were shot, the guns were placed on there, they have GSR residue. And what did she testify to? GSR does not go away. Unless you wash it down a drain, it blows in the wind, you wash your hands, it does not go away. The other thing we know about these gloves is that they're not shooting gloves. We know that. They're too thick to be shooting gloves. There's one of his gloves there, and we know that that is touching GSR. And that's what I submit to you those gloves were for. We know it was cold that day. We know he was getting kicked out of his house. We know that Cody gets cold all the time. His brother gets cold too. We know that he had gloves on that day, and they came from his closet. That's where the GSR came from. You don't have any GSR manipulating the bodies. You don't have any of that. You don't have any GSR on Chad's holster. You don't have any GSR on Chad's belt, do you? None of that. That all adds up to reasonable doubt. There's no other items that have GSR on them. Now, Erica Johansson testified, and she was kind of a reluctant witness, but she did interview him. He showed up at his interview that day, just like what he told Anderson. Just like what he told Anderson, he showed up. He was telling the truth. We talked about Sam Coors, about the gun in September. Now, ladies and gentlemen, this is my only chance to talk to you. The state talked a long time. I'm like the jelly, the peanut butter and jelly in a sandwich, okay, and they're the bread. The state has the burden of proving Grant's guilt beyond a reasonable doubt. I submit to you, they did not meet that burden. I am not saying that this was a drug transaction. I am not blaming Jason. I am not saying it was a random intruder. I've not put forward any of that evidence. I don't want to lose any credibility with you. I want to speak to you with credible evidence that was presented by the state, and I'm commenting on it now. They did not meet that burden. You swore you would follow the law, And that's why we chose you. Remember, respect each other's opinions. You know, we all promised we wouldn't get bullied. And when the time comes, render that verdict. And there's one verdict in this case, ladies and gentlemen, and that's not guilty. They did not meet their burden. Hold it to them. I'm sorry for what happened, but they did not prove Grant's case to the exclusion of a reasonable doubt. Thank you, Judge.
All right, members of the jury, we're going to take a brief recess before the state's rebuttal. So that way you guys have a bathroom stretch break, and I know I've got food back there for you, so you can have a snack too, and then we'll come back and do the state's rebuttal in about 10 minutes, all right? You may be seated. All right, so we're going to take a brief recess. We'll do about 10 minutes. You got 38 minutes left. All right.